Welcome to the iWills Legal Estate Planning podcast series. In each episode, Teresa Catalano and her guests will discuss key considerations and recommended practical legal approaches to ensure your estate is distributed according to your wishes. Episode 3, Testamentary Trusts and the Federal Government's amended trust tax reforms. Hosting the podcast today is Teresa Catalano. The information in this podcast is general in nature only and does not constitute legal advice. It does not take into account your personal circumstances. If you have a specific legal issue, you should seek professional advice from a qualified lawyer before acting on anything discussed in this episode. To iWills Legal's Estate Planning Podcast. In May 2026, the federal budget, the government proposed a new 30% minimum tax on the income of discretionary trusts, due to commence from 1 July 2028. Among estate planners, the alarm bells rang loudest over what it might mean for discretionary testamentary trusts. The trusts created by your will, long valued for their asset protection and for allowing income to be shared tax effectively among family members, including children, at ordinary adult tax rates. I'm joined today by Wills and Estates accredited specialist Teresa Catalano. Welcome.
Thanks, Rob. Nice to see you again.
So let's dive into it, Teresa. So for listeners who are hearing the term for the first time, what exactly is a discretionary testamentary trust? And why have they traditionally been such a popular tool in estate planning here in Australia?
It's a very important question, Rob, because to be honest, when these announcements were introduced by the government, it caused major confusion amongst the public because no one really knows, or that term discretionary testamentary trust wasn't sort of heavily used. A discretionary testamentary trust is akin to a typical family trust that someone might have set up during their lifetime, except it's set up under a person's will, and it only takes effect like any other part of their will when they've died. And essentially the trustee of that trust, just like a family trust, as I mentioned before, has discretion to determine where income and capital goes from time to time to the class of beneficiaries. It can provide obviously tax planning benefits to those beneficiaries, but also asset protection if it's structured in a certain way. The key difference to family trusts based on the current legislation in any event is the concessional tax treatment of minors that I know we're going to discuss a little bit later, Rob, but that's essentially what discretionary testamentary trusts are.
Let's set the scene with the original budget announcement in May 26. What did the proposed 30% minimum tax on discretionary trusts actually involve, and why did the estate planning community react so strongly when it came to discretionary testamentary trusts?
Yes, there was a lot of upheaval and uproar about it, to be honest. Certainly in my career, I've never seen anything like this in terms of the amount of traction or attention in this estate planning space that those May 26 announcements drew. Basically, when those announcements were made, the primary focus, as you might have seen yourself, Rob, was more so on discretionary trusts, which are the typical family trust that a lot of people in our community have. But it was a little bit of a hidden or an underlying sort of not so public message about discretionary testamentary trusts, which are the trusts and wills, that, as we said before. So a little bit, it wasn't apparent or as obvious in that initial budget announcement, but it sort of came out in the preceding days after that announcement. And I think various professionals sort of actually went to the budget papers directly and sort of sought to understand what does this mean, especially in the estate planning space, for discretionary testamentary trusts. And when people delved further into it, it was apparent that they were only going to exclude fixed trusts from being subjected to that proposed new 30% income tax on discretionary trusts, but not discretionary trusts, including discretionary testamentary trusts. And I myself saw a lot in the media from various ministers at the time sort of saying, well, no, estate trusts are excluded, it's only discretionary trusts, it's not fixed trusts. But again, what does that mean? Most people wouldn't understand, just to be, perfectly frank, most people would not understand the distinction between a discretionary versus a fixed trust under an estate, unless you're a loyal professional, obviously practicing in this space. So most trusts in wills that are established are of a discretionary nature. So when we think about testamentary trust wills, generally speaking, they are discretionary testamentary trusts and not fixed trusts. Fixed trusts are just like an estate that's held on trust for a particular beneficiary or even a minor until they're of a certain age. But it's clear that the assets and the income of that trust will vest in that one person, in that, or those couple of people, those beneficiaries. It's not discretionary. There's no class of beneficiaries of which the trustee can exercise discretion and can consider who to distribute to. So back to your question, Rob, the reason why there was so much concern is because then in the estate planning space, it became apparent that the discretionary testamentary trust structures could absolutely be caught by this new proposed legislation.
Oh no.
Yes.
That's not
absolutely.
Good. Okay. Can you walk us through the problem with the original carve-out? As I understand it, it only protected trusts whose assets already existed at the time of the announcement, which is a strange position for something created by a will.
Yes, absolutely. I mean, at the end of the day, even when the announcement was first made in May, there was no draft legislation tabled. There's no law enacted. So to be frank, and I know we'll bounce back to this point later in our discussion today, but we really won't know until there's any form of at least draft legislation for us to really review and sort of dissect. But yes, I mean, it was really at the stage of those first announcements, there was no real carve-outs at all, to be frank, on discretionary testamentary trusts. And on discretionary trusts, it wasn't clear itself that there were going to be, in terms of your family trust, any carve-outs either. It was just very loosely, aside from fixed trusts, anything of a discretionary trust nature, we're going to introduce that 30% tax for. And yes, we'll have to look at this down the track. And yes, there may be carve-outs, but that wasn't sort of tabled or detailed in any particular sort of, or in the budget papers themselves at that point in time.
So we move forward. On 18th of June 2026, the government amended its position. In plain terms, what's actually changed and how much better off are families now compared with where things stood on budget night?
Yes, look, I think that was definitely a response to the media, the public's reaction. As I said, there was a lot of upheaval, a lot of uproar, major confusion. And the government then released this consultation paper, obviously in June, and has gone out to particularly professionals in this space saying, we want feedback, we need to understand, how do we define these terms? If we are to introduce legislation, what is it going to look like? So there was more clarity that was given to this proposed 30% new income tax on trust. And just to be clear, it's not a tax on capital, because I know that some clients have come to me on that particular question. It's a tax on income. So it's not going to affect the capital of the trust, it's a tax on the income. So what became clearer as a result of the June consultation paper that was released was that in terms of discretionary testamentary trusts, they would now be excluded from this proposed new 30% tax, as long as they were incorporated in the will for genuine testamentary purposes, and I'll get back to that later. But they also may only capture the assets of the estate. So once they're set up, the person's died, the trust is live, and in effect, if you add other assets to that trust, which you can do even now under the current legislation, but you're not going to get the same concessional tax treatment. And that it would only apply to income from unrelated assets that was injected into that trust after budget night, so after the 12th of May 26. And then The other thing that sort of has come out, or the further clarification on discretionary testamentary trusts, is that from 1 July 28, right, they are proposing to now say that we will only exclude the new or discretionary testamentary trust from being subjected to that new 30% income tax if the beneficiaries of that trust are confined to individuals and tax exempt entities such as charities, right? So not obviously having the usual more broader generic class where it'll say sometimes you might find in wills that those discretionary trusts, testamentary trusts include companies and trusts. So they made that very clear, and they again reinforced or reiterated the message that any fixed trusts such as special disability trusts, other fixed trusts that are created by wills, or your fixed trust now, like a unit trust, for example, would be excluded from being subjected to that new tax. The one thing that estate planning lawyers particularly were waiting to hear was that, and this then was sort of clarified in that consultation paper in June, was whether or not the concessional tax treatment of minors that testamentary discretionary trusts give us right now would be preserved, because that was something that hadn't been clarified. And as a result of this consultation paper, it now appears that it will be, which is a major tick for estate planning and for tax planning in terms of your succession planning. But as a result of the release of this consultation paper, it's also become clearer that it seems very likely that the new 30% tax will come into play as concerns your typical family discretionary trusts.
Yep. Cool. So we've got the revised exemption and there's conditions. Where might people trip themselves up?
So people are very confused. People are writing to us saying we need to do away with our family trust, or we need to do away with our discretionary testamentary trust in our wills. We need to update our wills. We don't want a trust. So these are the implications these proposed changes are having, which we have formed in our office quite a different view. And I know some of my estate planning colleagues would bear the same view. And that is, let's just wait. We haven't seen the draft legislation yet. Things are just moving. As you can see, there's already been a lot of movement since the initial May budget announcement. So let's wait and see. Is the legislation going to even be drafted? It seems likely it will be, but once it's drafted, what does it say? Will it get through? Will it even be passed in that form or any other form? Who knows? So once we get at least a draft version of any sort of proposed legislation, I guess we're in a position to advise, and we'll do a follow-up to this podcast, no doubt, but to advise and guide our clients and the community as to what then needs to happen. But at the moment, we are saying sit tight. Keep your family trusts, unless your accountant's saying obviously for different tax unrelated legal reasons, but tax reasons not to. Keep that in play. Keep your will, if it was already suitable and advised to you to have a discretionary testamentary trust, keep it in there. And let's just watch your space. We will act quickly. We will definitely, and there will be a lot around this, I'm sure, from other people in the community as well as to what needs to happen. But right now it needs to stay. Now, I think the other thing even when the initial May announcements were made and we didn't have that further clarity that we now have, we advise people that these trusts do not only serve tax planning purposes, but they have a larger role to play in the intergenerational transfer of wealth, which can only be achieved via these trust structures. But also, if you're concerned or you've got vulnerable beneficiaries, or those beneficiaries are at risk of going through a potential family law relationship breakdown, or being at risk of being sued by a creditor, or they're not very good with their management of money, then trust structures are the only way to protect and to mitigate those risks. So again, even if these tax things hypothetically came into play, why would we want to risk that? So it's always going to be a balancing act, and it needs to be looked at holistically in its entirety, working with your other, accounting, financial advisors, etc. But it's a bit more of a detailed case-by-case analysis type discussion, as opposed to a blanket rule. Oh yes, these laws have come into play, let's get rid of our trusts.
Yeah, it's a really important distinction, isn't it? Because I think people have looked at discretionary trust traditionally as a tax planning device.
Yes.
Whereas in estate planning, in fact, their more important purpose is to protect the capital of the estate.
Absolutely. It's the only way that you can achieve that preservation of capital and to ensure that it's sort of succeeded down to the, the next generations, but also to the people you want it to be succeeded to, and that it's done in an asset protective manner. Now, I know in some of our earlier podcasts, Rob, we've discussed things around, what forms part of your estate and what doesn't, and mitigating the risk of will contests, for example, just to sort of recap on that point. Now, if you have assets in a family trust, that sits outside of your will, and therefore if there is attack on your will, the assets in that family trust are going to be protected, right? So we don't necessarily want to go off and get rid of our family trusts, even if the accountant, for example, says, oh yes, that makes sense to do that from a tax planning perspective, or because of these new tax laws coming in, because it may actually impact the overall strategy in us trying to keep things outside of the estate environment. So again, it requires careful thought and collaboration with each of your advisors.
Yep. Thanks, Teresa. That's been enormously helpful in cutting through what's a generally confusing area. Thank you for your time and your insight today. For listeners who'd like to discuss their own circumstances, please remember that this conversation is general information only and not personal, legal or tax advice. So do speak with a qualified advisor about your situation.
Thanks, Rob. And if there's anything else that comes up in coming days, months, we will definitely be updating everyone.
Thank you for joining us today in our exploration of the changes in tax treatment of discretionary trusts and discretionary testamentary trusts. We'll be back next month to explore another estate planning topic.